why proportionality law and proportionality test are important for effective protection of human rights.
Hello. Perhaps some people are wondering why to speak of the constitutional theory of law of proportionality and are eager to start formalizing the Nash equilibrium to optimize a collision of fundamental rights. However, the foundation of the constitutional theory of fundamental rights are essential to know what is the social problem that we intend to solve, as well as what if that we are going to model, optimize, and automate. For this reason, in the last episode we defined what weighting is and what its nature is. In this episode, we will study the social relevance of proportionality law for the effective protection of fundamental rights. As well as we will answer what are fundamental rights, how should a constitutional state of law exercise power without damaging human dignity and fundamental rights, what must be the state verified in any intervention on a fundamental right, what is the importance of a legacy weighting law for the effective protection of human rights, what is proportionality test, what are the guarantees of proportionality test for the effective protection of human rights, and finally, what must be the purpose of a democratic state in a legal system of fundamental rights. So, welcome to the Nash equilibrium in optimizing the constitutional principle of proportionality, a bounded model for collision between fundamental rights, episode 2.
Fundamental rights are general principles of law or principles of universal justice that are positivized in Constitution and in the international conventions. They contain a fixed and immutable core that must not be affected in any way. Fundamental rights are the product of rationality and autonomy of the will. For Kant, when the will that is autonomous changes to meet its passion and combat its weakness and fears by granting control of its behavior to reason, then the individual is an end in itself and therefore acquires dignity. However, in this circumstance, this is not an irrational freedom to satisfy his wishes without any limit. On the contrary, these powers make him a self-legislator, a rule of himself to select his own ends without turning his fellow men into means, mere instruments to satisfy needs or fulfill purpose. For this reason, the core of fundamental rights originates its rationality, autonomy of the will, dignity, equity, legal certainty, and therefore the constitutional and democratic state of law. This is the identity that the Königsberg philosopher observed between the concept of civil society and the rule of law. By virtue of rationality, human beings know that they are free and voluntarily deposit their autonomy, their sovereignty, because they believe in the democratic institution of the constitutional state as depositaries of its power. Powers they receive from the sovereign civil society organized to seek the common good of the people, the constitutional rule of law, which change their condition from subjects, means, to citizens, and it's themselves. Human dignity and human rights are essential for the development of personality, so their involvement may be legal to various degrees, so that any involvement of the core of fundamental rights is illegal. Starting from the basis that, due to their gradual nature, fundamental rights cannot be cancelled or be absolute, and their exercise is subject to limits. The expansion of a fundamental right to the detriment of another may be illegal.
All fundamental rights protect dignity and some other fundamental rights. Therefore, the common characteristics of all fundamental rights is the dignity.
According to the Article 1 of the Basic Law for the Federal Republic of Germany, human dignity, human rights, legally binding first of basic rights, human dignity should be inviolable. To respect and protect it should be the duty of all state authority. The German people, therefore, acknowledge inviolable and inalienable human rights as the basis of every community of peace and of justice in the world. The following basis rights should be by the legislature, the executive, and the judiciary as directly applicable law. In this sense, in the exercise of state power, abuses or omission that violate fundamental rights can happen. For this reason, the competence of the state to restrict fundamental rights must be subject to multiple restrictions, or as is often said, expressed in constitutional jurisprudence and German doctrine, the limits of the limits. If, on the contrary, it does not happen, the strict restriction will be vitiated by unconstitutionality. In the United States, ponderation began to develop as a method of interpretation and application of the law from the decade of the 20s in the constitutional jurisprudence of the Federal Supreme Court. And it is an important element of proportionality which the European constitutional courts have adopted with great enthusiasm. But then, according to constitutional theory, how should the state exercise its power without damaging human dignity and fundamental rights of the people? In Mexico, the principle of proportionality has been adopted in the Supreme Court of Justice resolutions, the Federal Electoral Justice, and the Appellation Circuit Courts. According to the jurisprudence of the Third Room of the Supreme Court of Justice of Mexico, for any intervention on a fundamental right, it must be verified that the intervention on a fundamental right serves a constitutionally valid purpose, that the measure is suitable to satisfy to some extent its constitutionality purpose. There are no alternative measures equally suitable to achieve the aim chased but less harmful to the fundamental right affected. The degree of achievement on the aim chased is greater than the degree of affectation caused to the fundamental right by the legal challenged measure. As we see in the last episode, principle of proportionality is divided into sub-principles: adequacy or suitability, that represents the degree of suitability of the measure or act of authority, the degree of probability of being suitable or adequate. The sub-principle of necessity, that represents the degree of necessity of the measure or act of authority, the degree of probability that the measure is necessary, and the proportionality in the narrow sense, the degree of legal proportionality of the measure or act of authority. According to Alexi, a collision between fundamental rights can be modulated rationally by operating with a scale of intensity range. In this sense, a conflict of interest should be protected by optimization. In words of Alexi, the problem of power structure is therefore the central problem of power in constitutional law. Alexi's contribution to legal culture have achieved wide and well-deserved international recognition. In particular, his founding law is a benchmark science. This is a considered legal theory in constitutional law. In the domain of the scientia juris, represents epistemological architecture carefully designed to reproduce the balance and subtleties of the principle of proportionality applied in multiple constitutional courts. It has been recognized as an understanding initiative theoretical robust to weighted suitable axiological concepts with a high level of abstraction, of regret complexity, expressed as legal principles that activate behaviors, attitudes, responses, and emotions in the deepest of the human mind. Regarding the controversy about what is correct from the perspective of the Constitution, Alexis states that immeasurably appears as soon as it excludes the possibility of a common point of view. A discourse of the correct answer would be impossible beyond rationality and empty rhetoric. However, the opposite is true. If it's a rational discourse is possible on what is valid from the perspective of the Constitution, then it is possible to preach the existence of a common point of view. In Mexico, for the Supreme Court of Justice, the fundamental rights and their respective limits operate as principles, in such a way that the relation between the law and its limits enclose a collision that must be resolved with the aid of a specific method called the proportionality test. Especially, the application of the founding law is necessary when, by means of an appeal of unconstitutionality, a court review a certain measure that disproportionality affects the exercise of one right of the detriment of another. In addition, regarding the proportionality in the material susceptibility related to legislative measures, in the case of a specific prohibition by discrimination, the jurisprudence of the court considered that the legislative measure is proportionality when it maintains a reasonable relations with the purpose that is sought to achieve, which implies a bounding between its advantage and disadvantage, in order to verify that the damage caused by the differential treatment are not disproportionate with respect of the objectives pursued. Hence, the proportionality test requires checking whether unequal treatment is terrible, taking into account the importance of the aim pursued, on the understanding that the higher the hierarchy of protector interest, the greater the difference may be. After Second World War, humanity learns that principles are sacred and rules not. In the numerous rights, the Nazi defendant justified the behavior because it was in accordance with the law, a law that was contrary to human dignity and the principle of universal justice. Therefore, any rational being can understand, based on the Kantian categorical imperative, that such law was inhumane and therefore illegal. Since they themselves wouldn't not want to suffer in their own flesh or with that of their family and friends the crimes they commit against humanity. In cases of control of conventionality, especially the American Convention, does not impose a specific model to perform a control of constitutionality and conventionality method for weighing legal principles or human rights. We can solve the problem of conventionality by harmonizing among several regulatory frameworks belonging to the same legal system. The definition, the limitation, or legal precision that is most favorable to the case is being judged in order to confer maximum protection to the people in terms of their human rights. Therefore, when we analyze the legitimacy, validity, and rationality of the normative restriction or act of authority that violates human rights, the principle of proportionality is a necessary instrument in the study of conventionality. Camino Vidal points out that in legal practice, proportionality has become a general principle in all areas of community law, recognized in the Maastricht Treaty, Article 3b, also constitutes a canon of jurisprudential control of the Court of Justice of the European Union, and even recognized in the jurisprudence of the European Court of Human Rights. Furthermore, it should be mentioned that according to material humanitarian law and the Roman Statute, the principle of proportionality is the legal basis for definition and delimiting war crimes when the disproportionate death of civilians occur in an armed conflict. The foreign entails for the military authorities the main and permanent obligation to weigh the collateral effect to the attack incidental civilian causalities in relation to the expected advantage. To this effect, Moreno Ocampo, former prosecutor of the International Crime Court, states that a crime occurred if an international attack is committed against civilians, principle of distinction, Article 8.2b, or an attack is launched with a military objective in a knowledge that incidental civilian injuries will be clearly expected in relation to the anticipated military advantage, principle of proportionality, Article 8, paragraph 2, letter B. Due to this consideration, it is conventionally permitted for every sovereign state to defend itself unilaterally in order to repel an attack provided that the response is proportionally to injury suffered, from which it followeth that, sadly, repulse must be suitable, necessary, and proportionality in the narrow sense. The foregoing is understanding that during an armed conflict between democratic states, human dignity must be recognized as an inalienable, impersonable, and inviolable legal asset of democracy, freedom, and the constitutional state of law. When a measure involving fundamental rights fails the test of proportionality, warranties motivation established in Article 16 of the Constitution of Mexico and the mandate of implementation of human rights set forth in Article 1, the standard for a parameter of control of constitutionality. Article 16 related to the obligation of a written order or the authority to found and motivates the legal cause of any process. Article 1 set the obligation of the state to interpret the norms related to human rights in accordance with Constitution and international treaties, favoring people at all times border protection. Even more, all authorities have the obligation to promote, respect, protect, and guarantee human rights in accordance with the principle of universality, independence, indivisibly and progressively. Consequently, the state must prevent, investigate, punish, and repair violations of fundamental rights. In this sense, we can say that the final purpose of a democratic state in the century 21 is to promote, respect, protect, and guarantee dignity and human rights progressively. This purpose should be the purpose of all the public institutions of the state.